Again, hi everyone and welcome. My name is Zufita van Geden and I am the Associate Director of Graduate Studies for the MS program in Bioethics and Medical Humanities at Tulane. I'm very excited to welcome Dr. Mary Faith Marshall to give a talk to our faculty, students, and everyone joining us today. Before I introduce her, I would like to say a few words about our sponsor. We have two sponsors. So the first one is Dr. Juniors Williams Seniors. So this endowment initiated in 2013 to honor the legacy of Junior Richard Williams Seniors. Dr. Williams graduated from Tulane University and was a very well-known and very appreciated oncologist in Selma, Alabama. He loved medicine and he was very dedicated to his patients. He was interested in the impact of spirituality on health and the well-being of his patients. So this endowment supports lectures on spirituality and ethics in health at Tulane Schools of Medicine, and it's hosted by the MS program in Bioethics and Medical Humanities. The co-sponsor of this talk is also Tulane's MS program in Bioethics and Medical Humanities. This program offers two tracks, the Bioethics track and the Medical Humanities track. Both tracks emphasize teaching and research, but each one is slightly different. The bioethics track focuses on philosophy, law, and policy, while the medical humanities track explores healthcare through the lenses of history, cultural studies, literature, and the arts. This program can be completed in 1 or 2 years. It is designed to accommodate a range of students, those who have completed their BA, students enrolled in Tulane Schools of Medicine, or mid-career professionals who want to extend their knowledge in bioethics and medical humanities. If you want to know more about us, if you're interested, you can just Google Tulane Bioethics and you will find our website. You can also contact Dr. Hanson. He's the Director of Graduate Studies. I can post both our emails and me. I will post the email, and if you are interested or if you have any questions, feel free to contact us. So, and I would like to introduce our speaker. So Dr. Mary Faith Marshall is the Emily Davey and Joseph S. Kornfeld Professor of Biomedical Ethics and Director of the Center for Health, Humanities and Ethics at the University of Virginia School of Medicine. She co-founded its program, Studies in Reproductive Ethics and Justice, and she is Professor of Public Health Sciences in the School of Medicine and Professor in the Department of Acute and Specialty Care in the School of Nursing. Dr. Marshall received the Trailblazer Award from the National Association for the Advancement of Colored People in 1999 for her work in policy approaches to perinatal substance use disorder, and has testified on this subject before Congress and in U.S. District Court. She was a member of the American College of Obstetricians and Gynecologists Committee on Ethics for 11 years and is the primary author of its opinion 664, Refusal of Medically Recommended Treatment During Pregnancy. Dr. Marshall has served on a number of National Institutes of Health boards, including the National Institutes of Allergy and Infectious Diseases, Divisions of AIDS Prevention Africa, DSMB, and its International DSMB for Africa. She chaired the first NIH review panel on global health research involving human subjects. She also chaired the National Human Research Protection Advisory Committee at the U.S. Department of Health and Human Services. She has published widely in the area of reproductive rights and perinatal ethics. Two more things before I hand it over to Dr. Marshall. This talk is available for CME credit, so we will post a link in the chat. Please click it and enter the required information if you are interested in this credit. Also, feel free to post your questions in the chat. We will get to them at the end of the talk. So with that, I will stop sharing and hand it over to Dr. Marshall.
Thank you so much. Thank you all for having me. I really appreciate it. And thanks to everyone who's joining us virtually. So I'm going to share my slides now, and we're going to have some storytelling and some policy review. And I'm really looking forward to hearing from you all after the slide presentation, because that's always the most interesting part of any talk. So this is the cover of a card last time that that I bought last time I was in London, and you can see that it's basically a parody of kind of a British parlor comedy, if you will, although generally when you see these sorts of things, the women or the ladies are in the parlor while the men stay at the table and smoke cigars and have their after dinner cordials. And so this is a flip on that. I'm showing this because I want to make the point right up front that even though this may represent a move forward in terms of, feminist thinking and reality, that that even this, right, does not represent pregnant persons, pregnant women. And I want to acknowledge that you do not have to be you do not have to be a woman in terms of your gender identity to be a pregnant person. But that pregnant people are subject to bodily intrusions, incursions against their fundamental rights to refuse treatment or provide informed consent that would never happen or be tolerated in non-pregnant persons. The ACOG Ethics Committee opinion on refusal of medically recommended treatment during pregnancy was mentioned in the introduction. And I tell people I can die happy right now that that this is done. I was the first author on this Ethics Committee opinion. And because of some of the cases that I'm going to describe to you in a few minutes, we did not mince words, as you can see in this committee opinion. It replaced a committee opinion that was entitled Maternal Decision Making and the Law. And we wanted to get right at a pregnant person's right to refuse, a decisionally capable pregnant person's right to refuse treatment. So you can see here that we say pregnancy is not an exception, right, to the principle that a decisionally capable patient has the right to refuse treatment, even if it's needed to maintain the pregnant person's right. And therefore, a decisionally capable pregnant woman's decision to refuse medically recommended medical or surgical interventions should be respected. I would like to have said must, but that's not the format for ACOG opinions. We said the use of coercion, which is what this conversation that we're having is about, is not only ethically impermissible, but medically inadvisable because of the realities of prognostic uncertainty and the limitations of medical knowledge. And we know that in cases of coercive interventions in pregnancy, somewhere around a third of the clinical assessments that are made by physicians or members of the medical team are inaccurate. And so it is never acceptable for OBGYNs to attempt to influence patients toward a clinical decision using coercion. We also discourage OBGYNs from the use of duress, manipulation, coercion, physical force, or threats, including threats to involve the courts or child protective services to motivate women towards a specific clinical decisions. And in the cases that I've been involved in as an expert advisor or an expert witness, often, it doesn't part of the coercion involves, right, involving the court, or a threat, or the reality of involving child protective services. It's not ethically defensible to evoke conscience as a justification to attempt to coerce a patient into accepting care that the patient doesn't want. And if there's an adverse outcome that happens after an obstetric patient has refused recommended treatment, then there should be resources and counseling. And I would say not only available to patients, but available to the clinicians who are a member of that patient's care team, because my sense is that there's probably a fair amount of moral distress that those clinicians experience. Okay. The college discourages medical institutions from pursuing court-ordered interventions. I'm going to talk about 2 cases specifically where that happened, or taking any action against OBGYNs who refuse to perform them. Remember that a court-ordered intervention is not really an order, it's an authorization, right? It doesn't mean that you have to do what the court has authorized. And that we support OBGYN's refusal to participate in court-ordered interventions that violate their norms or their consciences. So I want to, let's look at some data here. This is a study that was published by Pregnancy Justice. It's an organization that was founded years ago by Lynn Paltrow, who's a very well-known attorney who has represented people in a number of well-known cases and not so well-known cases that involve coercive interventions in pregnancy. And so they did a study where they found cases of pregnancy criminalization in 46 states and US territories. Interestingly, and perhaps not surprisingly, almost 4 and 5 of those, practically 80% of those arrests, took place in just 5 southern states. So Alabama, South Carolina. South Carolina doesn't surprise me. I'll mention an important case in South Carolina that went all the way to the Supreme Court that involved coercive interventions in pregnancy: Tennessee, Oklahoma, and Mississippi. And as you could see from the earlier slide, Alabama represents almost half of pregnant persons who have been arrested. And they found that almost close to 80%, right, 77% of those cases occurred in states that had expanded the definition of child abuse to include fetuses, fertilized eggs, and embryos. South Carolina was the first state to do it, and I'm going to show you it. I'm going to mention that case to you in a few minutes. So this is interesting. Although there's a long history of criminalization, it has accelerated, and it's really accelerated over the past few years. So the Pregnancy Justice Report found almost 1,400 criminal arrests of people, some of them who were involved in more than one case, took place over 16 and a half years between January 1st of 2006 and June 23rd of 2022, which was the day before the Dobbs ruling. Okay, this is a huge increase, right, compared to the findings of the earlier study, which was published in 2013, that reported 413 cases during a 33-year period. So over 3 times as many cases in half as many years. Okay. More than 9 out of 10 of those cases involved allegations of the co-occurrence of pregnancy and substance use disorder. And the 3 most common substances that were associated with arrests, with criminalization, were methamphetamine, cannabis, and cocaine. Okay. This is a still from a BBC documentary that was made in Charleston, South Carolina, where I was a bioethicist for about 7 years. And you see a pregnant woman whose hands are handcuffed to a belt around her waist. She has shackles on her feet, and her crime is having substance use disorder while pregnant. And she was one of almost 40 women who had their urine tested, screened without their knowledge for illegal substances, and were subsequently arrested, and many of them jailed. Okay. So interesting here is that almost a quarter of the cases that I referred to earlier involved the alleged use of legal substances. So opiates, prescription opiates, alcohol, and nicotine. And I think if you were making a public health case for healthy pregnancies and healthy outcomes of pregnancies for the pregnant person, the subsequent mother and child, that looking at alcohol, looking at nicotine, looking at environmental factors are far more important from a public health perspective than looking at substance use during pregnancy. So they found also, should not be surprising, that almost 85% of the cases involve charges against someone who was deemed to be legally indigent, meaning that they faced considerable financial hardship. Incurring legal fees would mean that they would be unable to avoid basic life necessities. And we see this, over and over again, not just in this context, but, if you look at the effects of pandemic and so forth, the social injustices persist across the board in many areas of public health and clinical care. Okay, so here's an interesting thought, right? That if we think, how is information shared about a patient's private health information? How does that get to law enforcement persons, right? How does that lead to arrest and incarceration? Most of them, right, or a fair number of them, come from medical professionals or hospital-based social workers. Most common basis for pregnancy criminalization: clinicians in hospitals. 1 in 3 cases were first instigated by a medical professional. 2 out of 5 involved family regulation workers. And then again, just harkening back to the point that I made earlier, poor Black pregnant persons, poor white pregnant persons bore the brunt of the consequences and bear the brunt of pregnancy criminalization. Black people represented 18.2% of arrests due to pregnancy criminalization from January of 2006 to June of 2022, but despite Black women making up only 13% of the US population. And interestingly, the same is true of poor white pregnant persons, and there's even a larger disparity for them. Want to talk about the war on drugs. So let's look back at the history of the war on drugs and its ultimate intersection with pregnant persons. So the war on drugs began in 1971 when Richard Nixon was president. He declared drug abuse, that was his language, to be public enemy number 1. And he increased federal funding for drug control agencies and drug treatment efforts. And I will, say that, thank you for this drug treatment efforts. We know that, fantasies such as Nancy Reagan's "just say no" really don't work, and that when we're thinking about policy and clinical approaches to substance use disorder, that we should really be thinking about both trauma-informed care and how we can treat patients who have substance use disorder while not having a fantasy that they're suddenly going to stop using. The DEA was formed in 1973 as a merger of 3 other offices that existed in the federal government at the time. It was a small component of law enforcement efforts in the federal government until Ronald Reagan was elected president. So in 1981, he really expanded. He did 2 things. He expanded the reach of the drug war, and he focused on criminal punishment over treatment, and what we would hope would be a harm reduction approach that led to massive increases in incarcerations. And you can see the numbers there for nonviolent drug offenses. Went from 50,000 in 1980 to 400,000 in 1997. This quote is from an article in Harper's Magazine, and it was published in 2016. It was an interview with John Ehrlichman, who was Richard Nixon's general counsel at the beginning of Nixon's presidency, and then became his domestic policy advisor. And this is, I think, epitomizes in a way the hypocrisy of approaches to perinatal substance use disorder and substance use disorder in general. So here's Ehrlichman in the interview saying, "You want to know what this was really all about? The Nixon campaign in 1968 and the Nixon White House after that had 2 enemies, the anti-war left and Black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or Black, but by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did." Now I want to talk about 2 specific cases that happened at the same hospital, Tallahassee Memorial Hospital. I remember I was sitting at my desk looking at a bioethics blog or listserv, and the heading "Rogue Obstetricians" came across my screen. And I do reproductive ethics, they're my thing, and so I had to take a look at that. And this was the case that was described there. It was a case involving a patient at Tallahassee Memorial Hospital where this woman was receiving her obstetrical care, and it centered around bed rest and the fact that the patient's obstetrician wanted to put her on bed rest, and she had 2 toddlers at home and didn't feel as though she could be on bed rest. And I'm going to show you in a moment that would have involved bed rest for 15 weeks, 3 months worth of bed rest for a woman with 2 toddlers at home. This paper, and I've highlighted the publication date, July of 94. Right? So the cases I'm going to talk about were years after the publication of this paper, and it was published in Obstetrics and Gynecology, which is known as the Green Journal, right? The publication of the American College of Obstetricians and Gynecologists. And it said, you can read this, right? Bed rest is used in nearly 20% of all pregnancies to treat a variety of conditions. There is little evidence of its effectiveness. The estimated costs associated with it, including hospitalization, lost wages, lost domestic productivity, range from more than 250 million to billions of dollars per year. Bed rest is used extensively to treat a wide variety of pregnancy conditions at substantial cost, but with little proof of effectiveness. We recommend that because this intervention has failed the test of effectiveness, its use during pregnancy should be curtailed unless randomized trials demonstrate improvement in a specific outcome. July of 94 in the Green Journal. Okay. This is a paper that was published in the same journal, right, in 2013. Therapeutic bed rest in pregnancy, unethical and unsupported by data. And this was a joint publication. One of the authors is my colleague and friend, Annie Lyerly, who is an obstetrician and bioethicist at the University of North Carolina and is former chair of the ACOG Ethics Committee. So Cochrane systemic reviews do not support therapeutic bed rest for these conditions, echoed in other comprehensive reviews. And thus, these authors' statement that prescribing bed rest is inconsistent with the ethical principles of respect for autonomy, beneficence, and justice. If bed rest is to be used, it should be only within a formal clinical trial. So from 1994 to 2013, we still haven't gotten there. So I'm going to talk to you about the case of a woman named Samantha Burton. And the language that I'm going to use comes from the amicus brief that was filed in that case. And these were the amicis, the ACLU of Florida, the American Medical Women's Association. So in March of 2009, the state of Florida succeeded in completely depriving Ms. Burton, who was a mother with 2 toddlers at home, who was suffering from premature rupture of membranes, but was not in labor in her 25th week of pregnancy, deprived her of her physical liberty and medical decision-making authority for the remainder of her pregnancy. So at the state's request, so Ms. Burton's obstetrician wanted her to stay in the hospital on bed rest for 15 weeks, right? And Ms. Burton said no. She was not allowed to leave the hospital. So at the state's request, the circuit court, because one of the Tallahassee Memorial's attorneys, petitioned the circuit court, ordered Ms. Burton to be indefinitely confined, which would have been 15 weeks if her pregnancy had gone to term. And this is the language in the court's finding. Against her will to any and all medical treatments, restrictions to bed rest, and other interventions, including C-section, that in the words of the court, the unborn child's attending physician deemed necessary to preserve the life and health of Samantha Burton's unborn child. The court heard the hearing by telephone, with Ms. Burton being required to argue her case from her hospital bed on bed rest without the assistance of an attorney or an independent medical opinion, right? Her request to transfer to another hospital was denied because it wasn't in the child's best interest at this time. The court approved the state's basically wholesale control over her liberty and medical care on the erroneous legal premise that the ultimate welfare of the fetus was a controlling factor. Okay, so think about this. Back to my earlier slide, incursions against pregnant persons that would never be tolerated in a non-pregnant person, basically a prisoner in the hospital. Okay, so she sued the hospital, and the following year, the Florida District Court of Appeals ruled that the court can impose unwanted treatment on a pregnant woman. However, look at the language, in the best interest of the fetus, without providing evidence of fetal viability. So once you have a viable fetus, then the door is open perhaps to unwanted treatment. Okay. Although they did say it's clear that that the state has to show sufficient evidence to satisfy the burden of demonstrating the necessity of overriding the patient's constitutional right to refuse medical treatment. This is interesting. Florida is the only state, right, that has in its constitution, state constitution, an explicit right to individual privacy, has no parallel in the United States Constitution, right? And so this is the language from the Florida Constitution. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life, right? Unless, of course, you're pregnant. So I was, my jaw was on the floor, I have to tell you, when I read about that case. I was just gobsmacked. So I went online and looked up Tallahassee Memorial Hospital just to see what I could find about that case. And I discovered another case that had happened almost a decade earlier, right? And, Tallahassee Memorial Hospital, your hospital for life, well, maybe for the duration of your pregnancy. A case involving Ms. Laura Pemberton, right, resulted in another lawsuit, and this is a photograph of Ms. Pemberton. So this was another case that went to court in 1999. It was a reproductive rights case, and I'll tell you about the particulars of that case. So Ms. Pemberton had a child via cesarean section and with a vertical incision. She wanted to have her second child, she wanted to attempt a vaginal birth this time, with VBAC, which is vaginal birth after C-section. The fact that she had a vertical rather than a horizontal incision did put her at higher risk for a uterine abruption, right? And she couldn't find an obstetrician who would assist her. So she decided to labor at home with a midwife. During her labor, she became dehydrated. She went to Tallahassee Memorial to the emergency department to get IV hydration, was hydrated there, went back home to continue her labor with her midwife, and the word went up, through the institution, again to the institution's general counsel, who then called the local authorities. So Ms. Pemberton, who is laboring at home with a midwife, is taken into custody by a sheriff and the state's attorney. They show up at her home. She's in active labor. They strap her legs together. She's forced to go to the hospital for a C-section against her will. She was not given representation, but a lawyer was appointed to her fetus. And when she later sued them for violating her civil rights, the U.S. District Court in Florida found against her, saying that her rights were outweighed by the state's interest in preserving the life of the unborn child. Okay. They dismissed her suit against the hospital. And interestingly enough, right, they held that a C-section at the end of a full-term pregnancy was necessary, right, because the physicians said it was necessary to avoid a, quote, in their language, substantial, my highlight, risk that the fetus would die during delivery due to uterine rupture. A risk of 4.6% according to the Tallahassee Memorial's physicians, 2%, according to Ms. Pemberton's expert witness. And again, they found that the state's interest in preserving the life of an unborn child outweighed the mother's constitutional interest of bodily integrity. And I will say that Ms. Pemberton has gone on subsequently to have 2 children using VBAC. So, prisoners in hospitals, prisoners in jails. I moved to Charleston, South Carolina from the University of Virginia in 1993, 3 weeks to start a bioethics program. 3 weeks after I started there, a lawsuit was filed by Lynn Paltrow against the Medical University of South Carolina, my employer, the city of Charleston, police department, and the local solicitor, a man named an attorney named Charles Condon. Under that policy, which allowed urine screening for illegal substances without the patient's knowledge, and subsequent requirement for continued prenatal care and substance use disorder treatment, without which persons would be arrested. There were almost 40 women arrested in South Carolina, in Charleston, which resulted in this lawsuit that went to the Supreme Court. I know you can't read this. I'm showing you this page. I'll show you the language in just a moment. I was a patient at MUSC. I got all of my care there, including my GYN care. So you can see the form: authorization for release of medical information, assignment of insurance benefits, personal liability, valuable release form, and consent for medical treatment. So this is the form that anyone coming in to one of the clinics at MUSC signed, boilerplate form. I'm going to read you the language here. Okay. Consent for medical therapy. Okay, and here's the relevant sentence that the defendants in Ferguson versus City of Charleston said constituted informed consent to having your urine screened for illegal drugs. Okay. I further consent to the testing for infectious diseases, such as but not limited to syphilis, hepatitis, and AIDS. And I further consent to the testing of drugs if deemed advisable by my physician. So the argument that was made by the defendant's attorney was this constituted informed consent to have your urine screened in the OB clinic without your knowledge, screened to have a toxicology screen of your urine. Okay. So interestingly, this document was actually part of the Medical University of South Carolina's medical policies. And, back then they were on paper, right? In 1993. So each unit had a big, fat old policy manual full of paper. This was in it, right? So this was part of the Medical University's policy. And it says here, this is a letter that goes to persons who have tested, pregnant persons testing positive for illicit substances, from Charles Condon, the solicitor, or the local prosecutor. If you fail to attend substance abuse and prenatal care, you will, and the word will is underlined, be arrested by Charleston City Police and prosecuted by the Office of the Solicitor. Sincerely yours, Charles Maloney Condon. Of the 38 women who were arrested, 39 of them were Black. The one woman who wasn't Black had written in the margin of her medical record by the nurse architect of this program, Shirley Brown, the high-risk OB case manager, boyfriend is a Negro. And she testified in federal district court to being an anti-misogynist. This is more of the policy, and I just want to show you what charges were to be filed, right, against the suspect. So, following criminal charges will be filed against the arrestee. If the pregnancy is 27 weeks or less, possession of whatever the drug was, cocaine. If the pregnancy is 28 weeks or more, possession of the drug and distribution to persons under 18. If the patient delivers while testing positive for illegal drugs and/or her newborn tests positive, unlawful neglect of a child. This is an article that was published in a journal called Policy Review by Charles Condon. Clinton's cocaine babies. Why won't the administration let us save our children? And I made the argument then, and I make the argument now, sort of again. Charles Condon was not interested in healthy pregnancies and with healthy outcomes for the most part. He was interested in, and South Carolina was the first state to make, right, under this rubric, a fetus, right, a person under child neglect and abuse laws. South Carolina was the first state to do it. So that's what all this was about. It's about abortion politics in the Deep South. Okay. And fetal effects of cocaine. I mean, should pregnant persons take illegal drugs or even some prescribed drugs during pregnancy? Ideally, no illegal drugs and drugs that are approved for use in pregnancy. This is a meta-analysis of fetal effects of cocaine. 33 studies. Here are the endpoints of interest. You can see them: major malformations, low birth weight, prematurity, placental abruption, premature rupture of membranes, and mean birth weight. Cocaine-exposed infants, they found, had higher risk than children of women who were exposed to no drugs in utero. But they did find that the adverse effects were nullified when they compared cocaine-exposed children to children exposed to polydrug use, but no cocaine. And so why am I putting this in there? Because in Charleston and in other places, right, the drug of the substance that was being targeted, right, or the persons being targeted were people using cocaine. Okay. And so this is from this same paper that I shown you here. Although the past few decades have seen a growth in the number and quality of studies, there's still a gulf between myths of prenatal substance exposure and scientific evidence of fetal and newborn effects. Two myths are particularly persistent: that drugs cause birth defects and that women who use drugs are unfit to be parents. And I'm going to show you one last instance of pregnancy criminalization. And it's the arrest and incarceration of a woman named Bebe Shui. This is her photograph, Indianapolis Metropolitan Police Department. So it's her arrest photo. There's another photo of Miss Shui. So in December of 2010, Miss Shui was running a Chinese restaurant in Indianapolis with her boyfriend, by whom she was 8 months pregnant. Just before Christmas, he tells her that he is married and is returning to his family, which was a surprise to her. She did not know this. She begs him to stay. He throws money at her, leaves her, weeping on her knees in the parking lot. She takes rat poison in a suicide attempt, writes a letter in Mandarin saying, "I'm killing myself and I will take this baby with me to Hades." Friends get her to the hospital in time to save her life. Her fetus delivered by C-section, died of a cerebral hemorrhage within 4 days. 3 months later, the newly elected prosecutor in Indianapolis brings charges against Ms. Shui, claiming that the rat poison that almost killed her had killed her fetus. The charges were murder and attempted feticide, and if she had been convicted, she faced 45 to 65 years in prison. So, want to note, attempting suicide is not a crime in Indiana unless you're pregnant. Okay. So, ACOG data. Suicide is the 5th leading cause of death among pregnant women, pregnant persons. A review of pregnancy-related mental health deaths, suicide, and accidental overdoses in 14 states found that 11% of pregnancy-related deaths were due to mental health conditions, and 63% of pregnancy-related mental health deaths were caused by suicide. So not a trivial number of people. There were a huge number of groups, 80 of them, right, who filed amicus briefs or signed on to them in Ms. Shui's behalf. What happened to Ms. Shui and has happened to other pregnant persons, often the charges are fueled by, quote, unborn victims of violence laws. And generally those laws are not, they don't relate to the pregnant person, but to someone who may injure the pregnant person and injure the fetus in the process. In February 2010, Ms. Shui was granted bail on appeal. May of 2012, the Court of Appeals refused to dismiss her case, back to jail. And in 2013, she pleaded guilty to a misdemeanor charge of reckless endangerment and was released, having been sentenced to time served. And one last point here, people are often surprised when I tell them about this. 36 states in the United States have pregnancy exclusion laws in their advance directive laws that require physicians to avoid the advance directives of pregnant patients, direct physicians to maintain life support or somatic support of homeostasis in the case of death by neurological criteria until a fetus dies or is brought to term. These pregnancy exclusions that were largely adopted in the 1980s are narrow, but can void an entire advance directive and restrict any treatment not directed at the fetus. So thank you, and I'm going to stop there and hope that we have time for a robust discussion.
Yes, thank you very much. Yes, we already have 2 questions, so we can start with the first one. I will read it. I see the need for us to include trans men for calling people who get pregnant people. One fallout of this approach means that bold-faced misogyny, like what you point out in this talk, is powerfully hidden by well-intentioned inclusive language. Do you see this as an issue? If so, do you see a way around it?
Can you read it again for me?
Sure. I see the need, and I think maybe you can also open the question, the Q&A at the bottom, but yes, I will read it again. I see the need for us to include trans men for calling people who get pregnant people. One fallout of that approach means that bold-faced misogyny, like what you point out in this talk, is powerfully hidden by well-intentioned inclusive language. Do you see this as an issue? If so, do you see a way around it?
So am I understanding correctly that we're talking about trans men who become pregnant? Yes. Do I see a way around it? That's a really interesting question. I've looked up data on the number of trans persons who become pregnant, and it's who gender identify as men. And unfortunately, there's not a whole lot of data there. I guess I would say that regardless of your gender identity, that there should not be, this going back to the ACOG committee opinion on refusal of medically recommended treatment in pregnancy. That should obtain for any person who is pregnant, regardless of their gender identity. Shouldn't matter. And if I could go back and rewrite that opinion, then I would certainly change the word pregnant woman in there, or the phrase pregnant woman, to pregnant person. So I hope that answers your question, that I was getting at what you were asking.
So the next question is, my guess is that incarceration would lead to worse mental physical health outcomes than occasional substance use, thinking of marijuana here. What would be more appropriate harm reduction strategy for this population?
Wonderful, wonderful question. I'm going to say that in 1993, right, when I moved to South Carolina and found out about this policy, the Southern Governors Conference had funded a study that was carried out in Pinellas County, Florida, looking at policy approaches, punitive approaches to substance use by pregnant persons, and their findings were known. And they found, again, prior to 1993, several things. So they found out that for pregnant persons who had substance use disorder, that the most effective means of treatment included therapeutic approaches where, I know this seems obvious, the persons providing therapy were not judgmental, right? That there were, it's going to relate back to the prior question, that pregnant women, right, have their own therapy groups, that mixing sexes in therapy groups, having them with men who tended to dominate conversations, was not as effective as having, gender differentiated therapy groups. That because most of these persons who had been arrested were mothers or parents of more than one child, that they needed to provide on-site childcare and perhaps transportation, right? And that was perhaps the ideal circumstance for this population in a therapeutic harm reduction approach. And I want to make a point here relative to this question, and that is the persons who are arrested and put in jail, some of them for Cornelia Whitner in South Carolina was in jail for 13 years. 13 years. So these persons who are arrested and put in jail not only don't have the opportunity to bond with their newborns and vice versa, most of them have other children at home, right? And so if you're put in jail because of this, that means that your other children, if you're lucky, are farmed out to family members or taken care of by family members. And if not, they enter the foster care system, the vagaries of the foster care system. So I think it's hugely hypocritical to say that punitive approaches, to substance use disorder and pregnancy have anything to do with the welfare of pregnant persons and their developing fetuses and their offspring.
Okay, so the next question is, could you please discuss treatment over objection in incapacitated patients?
Yes, that's a great question. An interesting thing in some of these cases of coercive interventions is there has been no formal determination of incapacity, right, that the pregnant person is incapable. I was involved in a case, and this is a public case, so I'll mention it because it went to court. Woman named Renate Dre in New York, who was she and her husband were were Jewish. They went to a hospital where they were hoping that, their religious beliefs and their culture would be honored. She did not want to have a cesarean section. She wanted to have a vaginal birth. And she had a long labor, and the obstetrician who was taking care of her wanted her to go to the operating room for a C-section. There was no fetal distress. And she said no. Right. And so the obstetrician turned to her husband and said, would you give me permission to take, Mrs. Dre to the operating room for a cesarean section? Husband said no. And the physician actually wrote in the medical chart, I'm taking her to the operating room. Right. So not only, the patient's refusal of recommended treatment was not honored. He went to her husband, right, without determining that she lacked capacity in any way, shape, or form. And regardless of that, even if you had been determined to lack capacity, right, the standard for surrogate decision making, right, is that the surrogate says this is what she would have wanted or they would have wanted, right? But yeah, it's extremely rare that that pregnant persons are declared incapable. Now, could one make the argument that in the heat of the moment, especially with inadequate pain management, that a patient may not be fully capable decision maker? It's possible, but again, whomever that patient's surrogate is should be using substituted judgment as the standard of surrogate decision making.
Another question is, a critical question that arises is whether the state should have any role in mediating medical decisions when there is a perceived risk to the fetus. Some might argue that the government intervention is justified to protect potential life. What is your view on this?
I think that it is in some circumstances, right? And it's not, again, we're not just talking about fetuses, we're talking, under this rubric, born children, right? And so that the state has an interest in its citizens and their well-being, including children. But where is the line drawn, right? And as one of my slides showed, this is true as a number of states, and it's growing, right? The state has an interest in born children, fetuses, embryos. I mean, keep going, right? Gametes at some point in the future, so I think there has to be a cogent argument made that would occasion overriding the refusal of a capable patient, whether that patient is pregnant or not. And again, that's why the language was there. It is there in the ACOG Ethics Committee opinion that pregnancy shouldn't matter, right? You're a capable patient. You haven't been determined to be decisionally incapable. You have a constitutional right to consent to or refuse treatment, period. And the state's interest should not outweigh that. So I'm kind of a hardliner.
Someone who missed part of the presentation asks if you can share the slides with the attendees.
With you all, yes, I'd be happy to share the slides with the folks at Tulane, or
so I'm not sure if this person from Tulane
if
doesn't.
you if they email me, Happy
Okay.
to share slides with them. My email is easy. My name's Mary Faith Marshall, and my email is mfm@virginia. You have to spell the word out, .edu. You can find me online easily.
Another question. First, the person says, fascinating presentation, and curious about other areas that are rich for bioethics, like work with a geriatric population, for example.
Yeah, one of my colleagues in the Center for Health Humanities and Ethics whose office is right next door to mine and actually directs the program in health humanities is a geriatrician. I think that area, is ripe for scholarly work and bioethics, um, uh, health policy work, scholarly work, especially I think in terms of trying to keep elderly persons, geriatric patients at home, right, rather than being institutionalized unless they truly are unsafe in their homes. And I think, we have that program at UVA. It's called Virginia at Home, that involves geriatricians, advanced practice nurses, pharmacists, social workers, right, who make home visits, and work really hard to try and provide the resources and the wherewithal to keep uh, you know, geriatric elderly persons at home if possible. And is it resource intensive? Yes, but I think it's often less resource intensive in the scheme of things financially than admission to a long-term care facility.
This is an issue regarding the SME credit. So if you are blocked by your facility or by the institute and you want to get credit, please email us. Email either Emily or send me an email and we will help you to add your information to the link. So Emily, if you can just add your email to the chat or my email, and so you can get the credit. So another question. So what would you recommend for a psychotic homeless woman who arrives to hospital for some care but does not want interventions and has a high risk pregnancy? How can we best support her?
Well, I think I would need to know how she's presenting, psychiatrically. Does she need to be admitted to have her an acute manifestation of her psychosis, ideally controlled? These are really tough cases, and we deal with them at our institution in the context of pregnancy and not pregnancy. And so if you are a homeless person, then there is obviously the high probability that there is psychiatric illness that's a comorbid condition. We have a program in our institution that actually follows these sorts of patients, and has it's called the at-home program. And so a number of these folks are unhoused, and our team will visit them where they, on the downtown mall, wherever they are. We'll try and find housing for them if they're willing or interested in accepting it, especially if they have an acute exacerbation of not just their psychiatric illness, but of a comorbid medical condition. Get them rooms in a hotel where they can stay for a while. Find them an apartment. I mean, it's a really, really tough problem, but I would not go so far. Again, I think that the rate limiting step there has to do with the nature of the acute psychiatric um, uh, admission. right? That they don't need to be admitted because they're pregnant. They need to be admitted to treat their psychiatric condition.
Nikki says, I'm in full support, but how do we also still punish those who kill pregnant women? In some states, they can be charged with murder of 2 people if both die. Example, Lacey Patterson. How do we keep the rules against the pregnant women abusers and killers, and also give a lot of understanding to autonomy and choice to pregnant women?
Yeah, this is, as you all know, I mean, that's the that's the nut, right? That's the central question in terms of where a number of states are going and have gone in terms of incursions against pregnant people. And it's not, you know, it's not necessarily just within the context of pregnancy. Obviously, if you assist a pregnant person who wants to terminate their pregnancy, then, you know, depending on the state, there can be legal actions brought against you. I think, unfortunately, what we're seeing, the reality is that there are now maternal health care deserts. I have a slide, I didn't include it, but obstetricians and gynecologists are just leaving because they're worried about the possibilities of legal ramifications against them, arrests, incarceration, losing their license to practice, and they're going to other states. And so I don't, you know, professional organizations need to lobby against it. People need to lobby against it. I think the most powerful thing is get out there and vote. Sorry, I don't have a magic answer to that one. Build a clinic right across the state line from a state that has, you know, coercive intervention policy or constraints on treatment of pregnant persons.
David says, the consent form in Charleston refer to the testing of drugs, not testing for drugs or screening for drugs. The language seems meant to confuse or deceive one into missing the potential consequences of signing. Do you agree?
Yes, I agree. And I'll tell you, and if you want to get in touch with me, feel free. The BBC made an hour-long documentary about what was happening at the Medical University of South Carolina. And I'm happy to send you a copy. It interviews Shirley Brown. It shows a pregnant person who's tested positive being interviewed by Ms. Brown. It interviews Charles Condon. It shows a pregnant person who has tested positive being arrested in her home and taken to jail and then being interviewed, you know, in jail. She was shackled to the bed when she had her child. It's and the amazing thing is that the then president of the Medical University of South Carolina, who has now died, James Edwards, who was a dentist, was Reagan's Secretary of Energy. He was a former right-wing governor of South Carolina. He thought this policy was, I mean, truly in his heart, he believed it was a good thing. And not the dean of the medical school, not a host of, you know, the director and medical nursing director of the neonatal ICU, ethicists, you know, nobody could persuade him otherwise. So it was, I think, a matter of, you know, voluntary ignorance or something.
One of the Tulane School of Medicine students asks, the common thread between the cases presented seems to be that the life of the fetuses are valued more than the life of pregnant people. Furthermore, the local policies presented exacerbate this. Given the political landscape, how would you recommend equalizing the values of the fetus and the pregnant person? This is a very serious question.
Yeah, it's a good question. And so I would say this. Um, I think the phrase maternal fetal conflict is an unethical construction of the relationship. I mean, for the most part, what is in the pregnant person's best interest is in the fetus's best interest. Now, is that always true? No. So if you are a pregnant person and you are diagnosed with a cancer and it's possible that chemotherapy may have teratogenic effects or other effects on the fetus, that is a hard decision. And those are complex decisions because it's not just about the pregnant person and the fetus, right? It's about, as in the cases I mentioned to you all, the other two children at home, right? The constellation of that pregnant person's world and their interests in terms of access to pregnancy termination, access to abortion. Can if you're forced to continue a pregnancy, can you afford another child? Right? There are data that show that children who are born um, to persons who are forced to continue pregnancies, that there's a negative effect both on those children and the families they're born into because of the circumstances of that pregnancy and that birth. Sorry, I just spit out my lemonade.
Yeah, okay. So the next person, I just wanted to thank you for this important presentation and for your body of work in this field. Another question, I think that we will I have three questions because we will have to end the talk, unfortunately. So the next one is, what if the baby in the aforementioned example was in distress and the mother and father of the full-term baby and the mother and father of the full-term baby states that they do not want a C-section, and the OB decides that the baby may die?
I think that's a tragic situation, but I don't think that, again, it gets back to the question that was asked before then, right? If you're trying to compare, whose rights win, right? That I think, in those circumstances, the pregnant person's, that person has the right to decide, right? And not to be taken to the operating room against their will. Let me frame it this way. There's a famous case of a legal case, McFall v. Shemp. One of the and these two men were cousins. One of them had leukemia. He needed a bone marrow transplant in order to survive. His cousin was agreed to be, worked up to see whether he might be a compatible donor. He was, right? And he was the best possible donor out there. When it came time to donate bone marrow, the cousin declined, right? The man with cancer sues his cousin to try and force him to donate bone marrow. And so it goes to court. Look the case up, McFall v. Shemp, or Shemp v. McCall, I should remember. But the decision by the judge was that, this portends the horror of the Holocaust. We are not going to tie people down, right, and extract bodily tissue from them. And if you think about it, donating bone marrow is a whole lot less intrusive than having a cesarean section against your will. So if that pregnant person had a baby, their 3-year-old develops cancer, and mom is a match for a donation, we are not going to tie mom down and force her to donate bone marrow against her will. right? We're not going to do that for a born child, right? And so extrapolate that to a fetus.
So I think that we will end here. There are more questions, and I think that they require more time, and there are comments about your presentation. Thank you very, very much for the wonderful presentation and for this important field and for your work on that. And I would like also to thank you for this wonderful presentation and very, very important. I would say that if you want answers to your questions and you did not get, please email us or please email Dr. Mary Faith Marshall, and she and we will be happy to direct you, and she will probably be happy to answer your questions. So I'm sorry that we cannot answer all these questions. I have another event and I'm late to it. So this is the reason why we need to end this talk. So Dr. Mary Faith Marshall, thank you so much for your talk, for coming to give us a talk to all our faculty and students and everyone else. And yeah.
Thank you so much. It was an honor to be here, and thanks everyone who was able to attend. Really appreciate it. Thank you. Thank you.